the state certainly sympathizes with mom and makes no statement, takes no position as far as whether the legislature got things right or not with the law. My understanding of the law is that dad is entitled to a modification on this one. I don't think there's unfortunately a whole lot of agreement on this one. State is asking for final order to confirm arrears and mod child support to zero and medical support to zero. Dad is incarcerated in 2021. He looks like he got 15 years on what I believe is a drug charge.
Mm-hmm.
Yeah, drug charge. Projected, the TDCJ has him getting out most likely in 2026. And so the state certainly sympathizes with mom and makes no statement, takes no position as far as whether the legislature got things right or not with the law. My understanding of the law is that dad is entitled to a modification on this one. So that's what we're asking for, but I don't believe that mom is in agreement with that.
All right. Thank you very much. Ms. Biggers, the state's right. I've got no choice on that. Once somebody's been incarcerated for 90 days, is going to be incarcerated for the next 90 days. The law says I cannot order them to pay child support. Okay, that's the law.
Of course, why wouldn't it be?
They changed it about 10 years ago. Before that, I used to order. They used to consider being in jail a voluntary act of the person who did it. So,
after 3 times, you would think it would be voluntary. I work 2 jobs, 4 kids, take care of all of them.
Yeah, well, ma'am, the fact is that he has no income is why the legislature probably went that way. But again, it's the law. But anyway, I'm gonna go ahead and I got to swear you as a witness. You're gonna get the opportunity to tell the court what you want the court to do here today. But the state does have to ask you questions about the other items dealing with unpaid back child support, so forth and so on. So at this time, ma'am, do you solemnly swear or affirm any testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
All right, thank you very much, ma'am. And I'll go ahead and allow the state to call your first witness at this time. Thank you.
Thank you, Your Honor. Actually, but before I call any witnesses, I would offer what's been marked as states 1 and 2. And I don't know that Ms. Bigger, in fact, I'm fairly certain she's not seen states 2. She may have seen states 1.
All right, Ms. Bigger, stage 1 in this matter is your spreadsheet that shows what monies have been paid through the state disbursement unit for child support in your case by the father. Is there any legal reason that this financial information should not come in evidence at this time, ma'am?
Yeah, I guess, I don't know. Yeah, that's fine.
All right, then. And stage 2 is a copy of the inmate information detail sheet that's published by the Texas Department of Corrections. Is there any legal reason this should not come into evidence to verify that the father is incarcerated and what his sentence is, ma'am?
No.
All right, so both stage 1 and 2 are admitted. You may proceed at this time, Mr. Diamond.
Your Honor, I guess I would just defer to Ms. Bigger if she wants to say her piece. Maybe I just pass the mic and let her say it.
No, that's a waste of my time. It's good. Whatever y'all feel like is in the best interest of my children is.
Well, ma'am, I don't consider this.
We do what the legislature says.
We're not saying that we agree that this is the best interest of your kids, ma'am. It's in the best interest of the kid. This man be out earning a living, taking care of his family. But obviously, that's beyond his grasp at this point. But again, the legislature has mandated that this is what I have to do. I've got to reduce what he should paid you in child support to a judgment. And as the state got those figures, so I can run those by Ms. Biggers, please.
Your Honor, I have the raw numbers. I haven't calculated the interest. If I could have just a minute to. Well, so the raw numbers would be as of October 31st, 18,156.67 on the child support that he owes.
Okay.
I mean, Your Honor, I can calculate the interest if the court wants it, but
it's simple. The interest is somewhere around $90, $92, $93 a month. So I'll go ahead and I'll look at order and repayment on that at 150. That's close enough to that.
Yes, sir. And then I can't do the math in my head the way you can. I guess the 2,141.62 is the medical support that's owed.
A little bit above 40, so I'll order repayment of that at $75 a month.
Yes, Your Honor.
right, repayment 75. All right, ma'am, I'm gonna reduce the judgment what he owes you in back child support, unpaid child support. By law, I've got to order that repaid. We do it at principal plus interest plus about an extra 50 against principal, and I did just a little bit above that, so I'm ordering 150 on that, reducing the judgment to cash medical, and order him to repay $75 a month on that. But obviously, he's in prison. You're not going to be getting anything anytime soon on either. But again, it's got to be set up financially for me to do it that way and protect you and your interests, because I've done that part. They shouldn't give you any problem about keeping the kids on any type of Medicaid or any type of other government benefits you're entitled to based on your circumstances. But I do have to lower the child support down to 0 and the cash medical down to 0 going forward. So, ma'am, is there anything that you want to say as far as the closing arguments or anything that you asked the court to do that I have? But the only thing I can look at today based on the pleadings are the child support circumstances. But is there anything else you're asking me to do here today, ma'am?
No.
All right. Is there anything else from the state at this time then, sir?
Nothing further, Your Honor.
All right. I know the state by procedural matters, ma'am, have to send you out a copy of it for your signature. You don't have to sign off on it if you don't want to. It's not saying you agree to it. It's just saying this is what the court ordered because this is what the court has to do. May Ms. Vickers be excused, Mr. Diamond.
Yes, Your Honor.
All right, ma'am, you're free to go, and good luck to you and the kids, and we're off the record. Thank you.
Thank you, Your Honor.